All right, this is case number 16-105-424. This is Community Alliance Credit Union versus Ella Mumford. The matter is before the court on petition to show cause. Your appearance for the plaintiff in this matter, please. On Community Alliance Credit Union, anybody here for Credit Union? Community Alliance, do I have Ella Mumford on the Zoom? Ms. Mumford? All right, it appears that no one has appeared regarding the petition to show cause in this matter. I'll review it at the end of the call with the intent to set aside the order to show cause. All right, the court calls case number 20162-584. This is Dearborn Pain Specialist versus City of Detroit. The matter is before the court, sent on for review on today's date. There is an indication the matter is settled. You may at this time, your appearance for Dearborn Pain.
Your Honor, Christopher Nisi, P62477, standing in for Aaron Duncanson today.
All right, thank you, counsel. Good morning to you. For the City of Detroit, please.
Good morning, Your Honor. Joel Ashton, appearing for the City of Detroit, P number 47039.
Thank you. Good morning to you, Mr. Ashton, as well. So update me. Has this been resolved? What's going on here?
No, Your Honor, we're coming up on the 1 year mark and there's been no action. I know that there's some difficulty with the prior counsel for defendant not doing something that should have been done, but at this juncture, we just simply want an order that says it gets paid within a certain amount of time.
Your Honor, I can give you an update. We were here about 30 days ago, discussed the status of the case, which essentially was that apparently this case had been resolved by prior defense counsel, but the paperwork had not been submitted to the city for submission to city council for final approval. As I indicated last month, I would submit that paperwork. I did submit that paperwork. And I checked in with the city yesterday and I have confirmed that that paperwork has now been actually sent for city council approval and is in their stack of papers to be approved. So we've done on our end what needed to be done, and now we're waiting for it to be reviewed by city council.
All right, and so the resolution of this matter is in fact imminent. Is that correct?
I'm sorry, Judge, I can't hear you.
The resolution of this matter is imminent. I mean, it's based on your estimation, it's taken care of, correct?
That's correct, Your Honor. And as I discussed last time, I wish I could say exactly when or how long it would take city council to actually respond to us. But yes, at this point, we're waiting for them to review it and presumably approve our settlement.
You know, Your Honor, if we had an order that said it would be paid within 7 days as we asked for in our motion, it might speed the process.
Well, in fact, it won't. And we discussed this last time, and I believe I indicated that I would follow up with the city, and I have, and we're just have to have it go through the process now.
Yeah, it's peculiar. Typically, these days take a while, but not like this. I'm going to go ahead. I'll sign an order that it be satisfied in 30 days after entry of this order. And I guess my thought is here that thanks to Mr. Ashton's involvement here, that we've been able to kind of move forward. It's almost like now we're looking back at what occurred over time. I don't know what the remedy is for that, but it looks like Mr. Ashton has moved it forward as much as it can be moved forward. But I will issue an order saying that the payment has to be made within the next 30 days. And I've signed the order to that effect. We'll get that out to the departments.
Thank you.
And Your Honor, I don't mean to interrupt, but would it be possible to make that at least a 60-day order? Because I hate to have this to be set up at this point to fail. Not only does this have to be approved by city council, but then as we all know, there's a separate process for the actual issuance of the check. And I'm just not confident at this point that even with my good faith efforts that I can make this happen in 30 days. And I understand the frustration on the other side.
Your Honor, I do appreciate Brother Counsel's work. If it's not paid, we'll take some action following that. And I think that that process is required in order to ensure that we don't have more lost in the cracks situation here.
Yeah, I'm gonna leave it at the 30 days because of the sense of urgency. I think that is appropriate at this point. I'll visit the issues that may be associated there. Hopefully, this puts another degree of urgency that will get it resolved. Again, this does not sit at the doorstep of Mr. Ashton. Unfortunately, somebody before Mr. Ashton got his hands on it. All right, but that's why we'll get a copy of that in the mail next few days. Good day to both.
Thank you, Judge.
Thank you.
The court now calls case number 22-177-882. This is America Lending and Financial versus Corral, it appears. Thomas is the last name. The matter is before the court, set on for hearing on a motion for a summary disposition in this matter. The record should reflect that the defendant has provided an answer to the complaint that was filed. The complaint in this matter alleges damages of $6,553.61. It alleges that those damages occurred secondary to the failure to complete a contractual obligation involving a rental. Your appearance for the plaintiff in this matter, please.
Good morning, Your Honor. Robert Zielinski on behalf of plaintiff P69250.
Thank you, Mr. Zielinski, and good morning to you, sir. I'm looking now for last name Thomas. I believe it's Corral, last name Thomas. If you don't assume, please say something at this time. I'm looking for Thomas, who reportedly lives on Salem Street in the city of Detroit. All right, the court, the record should reflect that the court did send out a notice of today's hearing. That notice was sent out on September the 1st, directed to counsel in this matter for the plaintiff, also directed to one Thomas on Salem Street. The address is the same as used on the defendant's answer, directing that defendant should appear for this hearing on today's date at 9:45 a.m. It's now 10:17. Counsel, you had any contact with defendant Thomas or anyone in regard to this motion or the hearing today?
No, Your Honor. We had a status conference, and Your Honor realized that the original notice didn't go to the address on her answer. So we reset it. And I also, in addition, filed this summary motion. So I know that my motion and the court notice went out to the address that she had in her answer, and she hasn't appeared. I haven't talked to her. I guess at this point, I'd like to request the court go forward with the motion for a ruling on the merits of the motion.
All right. And with regard to your motion in this matter, sir, tell me why you believe that that the motion should be granted under C10.
Sure, Your Honor. This is a claim for a deficiency from the sale of a used vehicle. Defendant defaulted on it. The motion speaks for itself. It's very straightforward and simple. The vehicle was repossessed due to non-payment. I put the deficiency calculation in the motion. She filed an answer just stating disagree. There were no other factual defenses, no other affirmative defenses. So I went ahead and filed this, Your Honor. I filed under C10 though. So I did attach the bill of sale and affidavit of my client attesting to the accuracy of the deficiency, and defendant has not filed a response. So we'd ask the court to grant the summary and enter the proposed order and judgment.
All right, I've had an opportunity to read the motion for a summary disposition and to review the calculations that are alleged therein with regard to the auction proceeds, repossession fees, disposal, preparation, etc., as well as the original contract in this matter that is attached to the complaint I also reviewed the defendant's answer to the complaint. That answer is in the form of general denials. There is nothing that has been expressed in the answer with any specificity. Simply statements indicating disagreement in each paragraph 1 through 15 of the form answer that was provided. The defendant has not appeared unless the defendant responded to the motion for summary disposition. Court, having considered all these matters, finds that the motion is on solid footing and will accordingly grant there is not a genuine material issue of fact, and the plaintiff is entitled to judgment as a matter of law. And I will enter the judgment at this time as prayed. I do have a judgment form. I'm signing that now. The judgment will be entered based on the motion, the granting of the motion for summary disposition. So, all right, counsel, we'll get that out to you and to the defendant in this matter. Good day.
Thank you, Judge. Have a good day.
The court now calls case number 22-178-921. This is Madison Heights Imaging Center LLC, doing business as Michigan Diagnostics versus City of Detroit. The matter is set before the court for a pretrial conference on today's date. I did previously sign an order of compelling discovery in this matter on September 12th, 2022. Your appearance for the plaintiff for Madison Heights Imaging. Please say something if you're on the Zoom at this time. For the City of Detroit.
Patricia Porter, P66989 for the City of Detroit.
Thank you, Ms. Porter, and good morning to you, ma'am. So what's going on here? I see that there was an order for compelling discovery, and I don't see the other side here today. Have you spoken with someone from Imaging?
Sure, Your Honor, I can update you. There was, the last time we were here, which was 9/12, you did enter an order compelling discovery. We had issued interrogatories, requests for documents, and a notice of deposition. And the plaintiff did respond to the written discovery, but has not cooperated in making the person most knowledgeable at Madison Heights available for deposition. I've requested it through notice, I've requested it through emails, and I generally get no response at all to those emails. The interrogatories were unsigned, so you know they haven't complied with discovery. Discovery is past the cutoff, and I haven't been able to get the deposition that I noticed. So I would move the court to dismiss the matter because it was indicated at the last status conference that if the discovery was not complied with, if the order was not complied with, the matter would be dismissed. I have not heard anything other than the submission of unsigned answers to interrogatories from the plaintiff, despite my requests for deposition dates.
And again, counsel's office or the plaintiff's counsel has not appeared today, and there has to be some indication, of course, that the case was in some degree of distress by virtue of the fact that the court had to compel discovery of this matter. Based upon the representations of counsel for the City of Detroit, it appears that the plaintiff has not acted diligently and in accordance with the order of this court to prosecute this matter as they have indicated was their desire by the filing of this action. Accordingly, the matter will be dismissed at this time due to a lack of response to the court order and a lack of diligence in advancing the cause of this matter. The case is dismissed.
Thank you, Your Honor. Would you like me to submit an order?
If you would, Madam Counsel, and just email it, and I'll get it entered right away.
Okay, that's fine. Thank you very much.
No. This is case number 22-182520. This is Coleman Imaging LLC versus City of Detroit. Matter is set before the court today. It's like a pre-trial conference motion. Well, pre-trial conference. Your appearance at this time.
Good morning, Your Honor. Ryan Jernigan for the plaintiff, P83482.
All right, thank you, Mr. Jernigan. Good morning to you. All right.
And good morning, Your Honor. Chris Michaels, P83156, on behalf of the City of Detroit.
Thank you, Mr. Michaels. Good morning to you as well, sir. So somebody update me. What's going on here? I see that there's an order to compel discovery, I believe it was. I signed that on the 6th of September.
Yes, Your Honor, and we did comply with the records that were requested, the ones that plaintiff is in possession of. Specifically, the defendant alleged that the services were unlawful because there were no medical licenses for the people who performed that. We provided those medical licenses. The other documents were overbroad and vague and are not in the possession of the plaintiff, but the plaintiff did answer all the discovery requests.
And if I may, Your Honor?
Yes, sir.
The medical license were provided, but the city did supplement the motion for summary disposition, pointing out that even though they were compelled to, plaintiffs still failed to provide the certificate of need that an MRI you need to perform an MRI in the state of Michigan. They merely stated it's publicly available and not releasing it, even though this court compelled them to release that information. So they did provide most of the discovery they were compelled to, with that exception, which is one of the basis for the city's motion today. I can proceed with that motion now, or we can.
If I may, Your Honor, the document that was not produced, we didn't just say, hey, you can go find it. We specifically said where the document is available at. It's available on LAR. It is public information. We did say specifically where you can find that information.
Is that correct, counsel?
Your Honor, even if that is correct, I did not find it anywhere on LARA. And if it is true, the total response is that the certificate of need is a matter of public record and can be found on Michigan's LARA website, which I could not find it myself after reasonable diligence. And the fact is, if it really is publicly available, they should have been able to turn it over. It just appears, I don't mean to, I assume they have one, but I have a responsibility to my client to show that they are lawfully providing services. And if it's a document that's readily available to plaintiff, it should have been turned over, as this court has already compelled. That is just one of the grounds for the summary disposition. I have every confidence that they are lawful, but without evidence, we can't legally conclude that they're lawfully rendering services.
All right, so I thought that I thought it was a separate question. I thought that you indicated to me that you received information regarding their lawful operations. You're saying now, it seems like the question that we're drilling down on now is a certificate of need. That's something separate and distinct. Is that correct?
Yes, Your Honor. They provided the medical licenses, but as was noted in the motion, they also need a certificate of need to perform MRIs, and they very may well have one. And that was one of the requests for production, which this court compelled, and nothing was provided. They just said it's publicly available. Go find it yourself.
Why not?
Once again,
Yeah. Before you speak, Mr. Jernigan, why not simply access that document and turn it over?
this was a time-sensitive matter, Your Honor, and the person who can produce that document, when I reached out to my client, they said they were out of town. But they are licensed. You can publicly look it up. We'll be happy to supplement that information as well. We were just worried about, the responses were due at a certain time.
All right. Any other issues relative to your motion for summary disposition, Council?
Yes, Your Honor. Regarding the rate and the customary uses of the rate, defendant in their summary just emphasizes that we don't produce any documents from any third-party biller and state that because we don't produce that, there's no way to establish that our rates are reasonable and customary. When they inquired how the plaintiff determines their rates are reasonable and customary, the plaintiff has performed a market survey of all the medical providers in the area, which the plaintiff can produce very easily, but the defendant never inquired about that. They specifically only asked for these specific documents and said, because we can't produce those, we cannot produce any evidence that our rates are usable and customary. And regarding the reasonable and customariness of the rates, that is addressed very thoroughly in our summary disposition if you want me to go into those arguments as well. But as far as they're saying we couldn't produce any documents, so we don't have any proof, we only answered the specific questions that they inquired about, and they never inquired how our client sets the rates. They just simply said in their summary disposition that we can't prove how they set the rates, but they never actually specifically asked us how the rates were set.
So let me get this lined up properly. So my understanding was the city brought its motion for summary disposition on the issues that we've been talking about relative to rights of operation and also regarding need of treatment. And then I see, all right,
So initially, Your Honor, their motion was saying that we couldn't prove the treatment was necessary and lawful, and we produced evidence of that. And then they said that we couldn't show that our rates are reasonable, but they never inquired on that. Sorry.
let me, a moment, Mr. Jernigan. Do you have a motion for summary disposition before?
Excuse me, I didn't hear you, Your Honor. I'm sorry.
Do you have a motion for summary disposition in front of me?
No, Your Honor.
Yeah, you threw me off because you said.
Oh, I'm sorry. I thought you meant like, was I the person who brought up the motion for summary disposition, or is there a motion for summary disposition?
I know there's a motion for summary disposition,
Okay.
but in your argument, you were saying an our motion for summary disposition, and I didn't see a plaintiff's motion.
I'm sorry. I misspoke, Your Honor. I can see the confusion in that.
Gotcha. Just wanted to make sure I had that part clear. Mr. Michaels.
Yes, Your Honor. I guess I'll just begin with the motion that this court previously took under advisement pending the discovery requests. But the city did supplement, and the plaintiff provided no response to it. So he appears to be giving his response orally. But there are three main grounds for why summary disposition is appropriate. First is that there continues to be no evidence that the claimant, Derek Martin, was injured in a vehicle insured by the city of Detroit. He just glosses over this fact. He never provides any indication. All the records provided just says he was in a motor vehicle accident on date. That is not sufficient evidence to create a genuine issue of material fact. At no point has there ever been any admissible evidence submitted by Mr. Jernigan or by plaintiff showing that the city of Detroit is the insurer responsible for some sort of injury. The second point was the lawfully rendering, which I just to reiterate, Your Honor, that generally that isn't a grounds for summary disposition because they have a medical license. They have a license to provide MRIs and they submit it in discovery. But I would defer to Judge Giles put it best that the point of discovery is to limit the issues of trial. And so they can't provide it. They just say, go find it yourself. Oh, we didn't have time, but yet a month has gone past and they still haven't supplemented. And they still will not provide the basic evidence that shows they are lawfully providing services. So that's sufficient grounds. The third ground is the accord and satisfaction argument. There are 4 days of treatment. There are 4 MRIs, and they seem to just completely concede, because they have never responded, that they were paid for 3 of the first 4 days. The days of treatment were, I believe, January 5th, February 23rd, March 23rd, which were all paid in full accord and satisfaction. And there's no dispute anymore as to that, even though they still claim that they should be entitled to more money. And then September 7th, 6 months later. And there is no evidence whatsoever that the first 3 dates were not paid in full accord and satisfaction. Which would bring to the next point, this reasonableness of bills. Plaintiff says, oh, if they would have asked, we would have provided. Well, the defendant has already submitted that there is no evidence of reasonableness, and they have not submitted anything admissible evidence to this court by affidavit, by admissible evidence, which the court rule requires to show that their rates are reasonable. As the city points out quite vigorously, September 7th, this last unpaid date of treatment, is after the fee schedule was imposed by the state of Michigan. The fee schedule would limit the maximum amount they could recover to about $418. And yet they charged $4,500 for this MRI. And now they're saying it's a question of fact as to reasonableness. And they're insisting on a trial by ambush. The defendant did ask specifically how these rates are asked. They asked in their request, in request 12, and provide total costs incurred by plaintiff, including an itemized list of all the costs incurred for providing services. And they say, we don't have possession of any of those documents. The cost incurred is reasonable under the Michigan Court of Appeals. I think it's Bronson Methodist Hospital case said the cost incurred is reasonable and discoverable. And then the defendant specifically asked for the amounts they accept from Medicare, Medicaid, Blue Cross, and uninsured persons. They simply say, we charge everyone the same amount, and then quote, payment amounts varies. The city of Detroit specifically asked for documentation on the amounts they accept from other parties, which is relevant and to the reasonableness of the rate, and is highly probative of the reasonableness of the rate. You can see the Spectrum Health case that outlines why it's reasonable. And they simply say payment amounts vary and provide no documentation to plaintiffs or to defendant, and no documentation to this court as to what amount they actually accept for the services they rendered. They simply say, well, if the defendant would have asked this really magical question, they would have gotten the correct answer of how we determine the rates. Defendant has asked the questions on how the rates are determined, and plaintiff merely insists on trial by ambush. They can't even provide a person who can testify to the rates because they have not submitted a witness list. They merely just pull out of the ether this idea their rates are reasonable and they deserve a jury trial, but failed to provide any discoverable information to the city on how their rates are determined. They say it's a black box and that we've done a market research and we've determined it is. Who is we? What information did you use? That the market rates may go to the customariness of the charge. They can charge everybody the same rate, but that has nothing to do with the reasonableness. The reasonableness has to be determined by evidence, and no evidence has been submitted to this court. And as to the last point, the medical necessity, they have also submitted no evidence to the city of Detroit to show this September, the only date which was not paid for, the only date that should be at issue in this case. The September MRI was medically reasonable for after 6 months since the previous MRI. They have submitted no order for an MRI. They have submitted nothing to the court showing the medical necessity and that it relates in any way to Mr. Martin having some sort of motor vehicle accident. Mr. Martin may very well have a chronic underlying condition, and that may have been why he had an MRI, but none of this information has ever been presented to the city and to this court, and so no genuine issue of material fact can be made. And it's crucial at this point because they insist on being paid some $20,000 for 3 MRIs that were already paid for and 1 MRI, which if they received the maximum legal amount was worth $400. So this is certainly a case of the city trying to audit the reasonableness of their rates and the plaintiff insisting they never need to provide evidence. They only can have to prove evidence at trial.
All right, let me ask you, Counselor, you indicated that that among the 4 elements of this claim, that 3 of them have already been paid, correct?
If that was to me, yes, Your Honor. It was in the motion. It states right clearly on the check, paid in full according to satisfaction of the dates listed. And there's been no dispute that that is in fact cash received, accepted, and paid in full according to satisfaction.
Okay, you got long answers to short questions.
Sorry, Your Honor.
What I'm getting at with that is that the city has already paid on 3 of these, and now it's questioning the reasonableness of the rate on this 4th item. That doesn't seem to be congruent. I get the other arguments as it relates to medical necessity. Does this in fact relate to rise out of automobile injury related to vehicle operated by the city of Detroit? But if you paid on previous ones, it would seem to me that the city has made a decision that the rates charged by such entity are reasonable rates. I don't see how you then make the argument now that three rates were reasonable, but this one is not reasonable, particularly where you've indicated to me that in the previous payments, one of them, at least one of them, were MRI related counseling.
If I may, Your Honor, the fundamental difference is the 3 paid-for MRIs were before the fee schedule imposed by the state. So the fact that we paid I think it was roughly $1,000. I'm not sure off the top of my head, but we paid an amount. Then the fee schedule took place, and the maximum amount the state would allow us to pay was about $419. So them charging $45,000 before the fee schedule may have been reasonable, but afterwards is certainly excessive and unreasonable.
All right, you said $45,000. I think that you meant 4,500.
Oh, yes, sir. Yes, Your Honor.
So counsel, you agree that the fee schedule would apply to the amounts that relate to September 7th, I believe, 2021?
I do not, Your Honor. I do not agree because of the Andre decision that was recently come out. So that is still up to debate. And then as far as the 3 previous payments that were made, I also do not concede that those were made in good faith and paid in full. And I can address that as well. That was the only issue not addressed.
Well, let me drill down on that one. Council has submitted an accord and satisfaction, if you will, a payment that was made and that was negotiated. So talk to me.
Yes, Your Honor, that is misleading to the court. It was not negotiated. It is a check that was automatically deposited into the plaintiff's account. The plaintiff does not have the opportunity to reject that. And in regards to it's just automatically deposited. It wasn't negotiated. They're aware that we're disputing it. That's the whole reason we filed a lawsuit. That is not satisfactory. So specifically, when it comes to that, pursuant to MCL 440.3311, a person against whom a claim is asserts proves that the person in good faith tendered an instrument to the claimant in full satisfaction of the claim, and the claim was unliquidated or subject to a bona fide dispute, and the claimant obtained payment of the instrument. If you want me, I can go over.
I understand the general principle that you're saying that.
I'm saying that it was the payment was made in bad faith, and that the plaintiff did not have an opportunity to dispute that. And in regards to that, yeah, like I said, it's just automatically deposited in their account.
Has the plaintiff accepted the payment or rejected it, sent it back, or what's the status of the payment?
It was deposited in their account. However, like I said, the whole reason that they filed a lawsuit, they're disputing it. It was just because they write accord and satisfaction doesn't mean that they accepted it. It has to say,
Did they strike the accord and satisfaction? Did they strike? Was there any deposit with recourse on the instrument or anything along those lines?
I don't have the specific instrument in front of me to answer that question, Your Honor.
Your Honor, it is attached as an exhibit. It's an exhibit 6. It's in the supplemental, and it provides. And if I may, Your Honor, I mean it's plaintiff speaking right now, but plaintiff forgot to read the rest of the full accord and satisfaction. They did accept payment, and it says, in fact, in the statute that that's subpart 3B. That the claimant must prove that within 90 days after the instrument, the claimant tendered repayment of the amount on the instrument against which the claim is asserted. So merely saying we filed a lawsuit is insufficient. They have to have repaid the amount. They have accepted in full accord and satisfaction. The whole point of the law is to avoid that it will get rid of the liquidated claim. And there's no requirement that they have to show they intended to accept it. They have to show that all the city has to show is that the payment was accepted, and within 90 days they did not retender it back and say that the dispute was still liquid. So The fact is they want to eat their cake and have it too. They want the payment, they want to keep the money, and they want more money. So that defeats the purpose of accordance satisfaction.
Under contract law as well, when the payment is made, it must be done in good faith. And in this case, the bills, as stated, were $24,750, and the payment made was approximately $4,457, which is 18%. That doesn't sound like good faith. And also, the city of Detroit constantly has suits against our client, so they're aware that the payment is not done in good faith because they have multiple suits. Unfortunately, I wish, Your Honor, I had the supplemental response that I'm reading to submit it to the court, but unfortunately, I know you don't have that in front of you.
I may very well have that.
I know. I mean plaintiff's response to their supplemental response. It wasn't filed within a fair and timely manner. I apologize.
Yeah, I'm concerned because obviously money was advanced. It was offered as a satisfaction of the claim. Money was negotiated. It was not refunded.
That's the point I'm trying to make, Your Honor. It was not negotiated. They just simply said they put the check in the account, said here, and wrote.
I use the term negotiated. I'm talking about it was put in the stream of commerce. It was deposited in the bank, and that is a significant issue in this case. All right.
Regardless, either way, Your Honor, like you said, there are still bills at dispute. They didn't pay at all on the other MRI.
Yeah, I understand that that's in dispute before the court at this time. It does appear to me that as it relates to the billings that have been presented herein, that the bills for which there was a payment made and a payment negotiated, and such payment was not returned, and no reasonable actions were taken to return the payment and to object to the payment that was advanced for 3 of the claims that are part of this action. I would have to find in that regard that the plaintiff is entitled to the grant of a partial motion for summary disposition as relates to those claims, in that it appears that those claims, by virtue of the payment that was made, the return offered as a satisfaction in this matter, have satisfied those 3 claims. As it relates to the remaining claim, the issues raised by counsel with regard to reasonableness of payment, and also whether or not this is causally related to the operation of a city motor vehicle, or whether the plaintiff has established that. It appears to me that those remain at this point questions of fact, and accordingly, the motion for summary disposition on those issues at this time would be denied. So I grant there's partial grant of the motion for summary disposition that disposes of the 3 claims that are attached to this matter. 1 claim does in fact survive, and court makes no determination at this point as to the amount of that claim. I understand that there are some factual disputes that relate therein. It is in fact the plaintiff's speak to reasonableness of rate that is required as a predicate to advancing the claim. It's also required that the plaintiff establish that the injury was caused by or is causally related to an accident that occurred involving a city. And so those are issues that yet need to be advanced herein. As it relates to the offer of discovery in this matter, for sure, the fact that or the ability to present or offer evidence in the context of the trial is going to be predicated upon whether or not the plaintiff has presented such evidence before trial, and where the defendant has requested evidence of the reasonableness of pay, where the defendant has requested evidence regarding the causal connection of the injury to to the operation of the city's motor vehicle and an accident arising thereof, those would be critical predicates to be able to present the claim at trial. And so while I'm denying the motion at this time, I simply reiterate, I think what is intuitive to everybody involved in this matter is that those items rest on the shoulders of the plaintiff to advance the claim. That's my ruling. I'll sign an order consistent there with upon presented to you. All right, good day, gentlemen.
Thank you, Your Honor.
Thank you, Your Honor. And would you like the city to submit the order, or well, I guess both council will have the language in there.
Well, I'm just saying, get it to me by email. I can get it signed up right away. I think my ruling is pretty clear.
Yeah, yes, Your Honor.
Let's get an order to me via email, and we'll get it signed right. Good day.
Good day, Your Honor.
All right, the court now calls case number 16-103758. This is Midland Funding LLC versus LaShawn Bird. The matter is before the court on a petition for installment payments, also on the defendant's petition objecting to a writ of garnishment as it relates to looks like Ultron Benefits Consulting. Also objections to a writ of garnishment as it relates to the Michigan Department of Treasury. The record should reflect regarding this matter that a judgment was entered by default. It looks like on the 18th of April 2016, that judgment is for $854.17. Your appearance for Midland, please.
Thank you. Good morning, Your Honor. Daniel Best, P58501 on behalf of Plaintiff Midland Funding.
Thank you, Mr. Bassett. Good morning to you, sir. I'm looking now for LaShawn Bird. If you're on the Zoom, say something at this time, please.
I'm here. I'm present.
All right. Good morning, Ms. Bird, and thank you for being here. I have gone over the documents that you've submitted to the court, and I'm looking. Just one moment. You're asking the court to make payments of $100 per month on the partial payment order, and then you've presented two objections to writs of garnishment. And both you indicate that you do not owe the money, and you also point out that the maximum permitted by law is already being withheld by the court's order. So money is being taken out of your pay. Is that correct, ma'am?
Not as of yet. It's in the process of being withdrawn, and I'm just trying to stop it because I can't. I'm having a real hard time right now. I just had a pay cut as of April 1st. Went from making $6,000 to $8,000 a month down to $4,000 to $5,000, and my bills remains the same or higher because of cost of living. So if I do owe this money, I'm willing to pay it, but I just need time to pay it in increments because I still need to pay utilities, rent, and eat. So if I indeed owe $854, I didn't know it was that much. I wasn't aware that I owed that much. I thought it was way less than that. But if I do indeed owe that much, I'm willing to pay it. I just need some time.
All right, ma'am. So yeah, the judgment was entered back in 2016 with some interest considerations. It's probably a bit more than that. Let me look at something else. All right, so counsel, let me hear from you. Well, let me ask you one more question, ma'am. So they filed a garnishment against your income tax return as well. How much money were you expecting from the Michigan Department of Treasury?
I'm not sure because I didn't receive income tax from the state. And also, I wasn't aware that this was in collections. I'm sorry.
Talk about the Department of Treasury now. Do you know if you have some money coming from them? Did you file your taxes?
Yes, but I'm not but I didn't pay attention to the amount that I was going to get from the state of Michigan. So I'm not sure how much was garnished or if anything was garnished from the state. I'm sorry.
All right, let me stop you now. Mr. Best, please.
Thank you. Good morning again, Your Honor. Your Honor, first, I just want to note that my client is not charging interest on this. The addition to the judgment amount was the garnishment amount of $15, garnishment court costs. So that's where that amount comes in from. As far as the two objections, I don't think either objection is valid, and I'd request the court to overrule both of those. As far as the motion for installment payments, we would concur, we would accept $100 per month starting November 15th, 2022. And, once that installment order itself would suspend the garnishment as of today's date. So any monies that would have been withheld prior to today should be paid over to my client. That should stop any further money from being garnished after today.
All right, do you have a readout on what amounts, if any, might be held by the state of Michigan?
I do not. We have not received any money from the state of Michigan as of yet, and we do not have a disclosure.
All right, Ms. Boyd, you indicated to me that your employer has not withheld any money at this point, correct?
That's correct.
All right, so listening to the objections on this, as I review them, I don't see a valid objection to the respective writs of garnishment. And so what I'm going to find is that there's not a valid objection. I'll immediately release any funds that are withheld to the plaintiff, and then I will suspend the garnishment. And I'll suspend the garnishment contingent upon the payment of $100 per month, starting on the 15th of November. And as long as the $100 is paid, then no further garnishment can be had as it relates to wages. So I'm signing that order now. And ma'am, if you'll chat your email address, then we'll get a copy of this order stopping or suspending the garnishment so that you can take to your employer. But you have to make that $100 a month starting on the 15th of November, or the garnishment will be put back in place. You understand that?
Thank you, Your Honor. Understood.
All right. So go ahead and make sure you chat that so we can get a copy over to you. Counsel, do you have the garnishment issue date?
Yes, Your Honor. Bear with me one second. The wage garnishment to Altruist Benefit Consulting was issued on August 25th, 2022. And
all right. I don't need the other one, but that one that was very helpful to have the wage garnishment item. All right, so I've got that taken care of, and I'll get these orders out to respective parties right away. Thank you, counsel. Thank you, ma'am. Good day to you.
very good. Thank you. Have a good day, Your Honor.
All right, this is case number 21-169-806. This is Autovest LLC versus Erica Dewan. It appears last name is Ray. The matter is before the court on the following objections to a writ of garnishment. The record should reflect that a judgment was entered in this matter on the looks like the 3rd of February 2022 for $5,545.80. That judgment was entered by default in this matter. So your appearance at this time, sir.
Judge, may I please court? My name is Attorney Richard Rusin. I'm the attorney of record for the plaintiff. My bar number is 35222. And today I am also the respondent to defendant's objection to a wage garnishment.
All right, thank you, counsel, and good morning to you, sir. I'm looking now for Miss Erica Ray, please, if you're all here, say something to me.
Good morning, Your Honor.
All right, good morning, Ms. Ray. I've received your objections to the writ of garnishment, and you point out in your objection that you were never served. You're talking about never being served with the garnishment?
Yes.
Yeah. Well, there's no requirement to serve you with the garnishment. That goes directly to the employer. So that's not really a valid objection in this matter. You are aware that the judgment was entered against you by default that February. That's what this is all about. Do you understand?
No, sir.
Yeah. So I have a document in my file indicating that the process server served you with this document, did the complaint in this case back in November 9th of 2021 at about 2:49 p.m. You were served at that location about this lawsuit. And then when you did not respond to that, that's when the judgment got entered subsequent to that time. All right, so that's why you have this $5,000 judgment against you. If you believe for some reason that there's some basis for which that judgment should not have been entered, you have to file a motion if you want to with the court seeking to have that judgment set aside if you believe that there is a reason why that judgment should not be in place. But that's not the issue today. The issue today is just dealing with the plaintiff's right to collect on the judgment that's already been entered. The judgment was entered in April. Now they have a right to collect because there is a judgment against you. So let me ask you about you work for Bose, is it? In Auburn Hills,
Yes,
is that
sir.
correct?
Yes.
So has any money been taken from you yet?
Yes, sir.
Right, so you get paid twice a month, is that true, ma'am?
Yes.
So how much money has been taken from you? I should say, how much is taken per pay period?
It ranges between 418 to 425. It's a 25% of what I take home after taxes.
Yeah, that's the, I know about the percentage, that's the law that allows the 25%. I just wanted to know what it was in actual dollars. So that turns out to be more than 400 per pay period, so over $800 a month. Is that correct?
Yes.
So you didn't submit to me a petition to make partial payments or some kind of way to start attacking this. So what did you want to do in this regard? I don't find a basis for the objection to the garnishment, but you might be able to seek some relief by way of what you could pay per month. So
Yes, I didn't know that it was a certain paper that I had to submit. So I do apologize about that. I do realize that the debt has to be paid. I just want to be able to make installments per pay period instead of the amount that's being taken out now.
all right. So why don't you talk with Mr. Rusin for a moment? Let's do that and see if you could let him know what you believe you could pay and see if we can reach an agreement. If not, you can always ask the court for an amount and establish what your obligations are, and then determine an amount. But it may be worthwhile to just kind of talk about it, to see if the two of you could reach terms and set up a way.
But yeah, Judge, I can just ask very quickly, depending on the record here, so we can move the case along. What does defendant think she can pay reasonably per month and pay that every month on this judgment?
I can pay $300 a month, so $150 out of each pay period.
Well, I will agree to that. You know, the court legal term is called stipulate. And if we do that, I see by my calendar that today is Wednesday, October 19th. Is your next pay period October the 28th?
No, so my next pay date is actually the 21st, and
All right.
the
Well, that's
payment is
well,
already
that's a little
taken out.
close. So what I will do is I will agree or stipulate that there be an installment payment order that will begin Friday, November 4th, and for $150 bi-weekly. And I will stipulate to that order. That way the court can enter the order today, send you a copy. Then you need to, I would recommend, send that to your paymaster directly when you get to work, because they know the right places to, you know, fax that, email it, whatever they need to do, so that your employer can stop withholding money out of your paycheck. And you might also, while you're there, present your paymaster with a copy of the court's order that will be mailed out, so that you know, you can make possibly arrangements with your employer to have that automatically deducted out of your paycheck. You'll have to flesh that out with your employer, you know. But I've seen that done many times, and maybe it can be done here.
So yeah,
And we are agreeing to the $300 a month.
$300 a month. You say $150 every paycheck, which is bi-weekly. And yes, that's what we're doing.
Okay.
Okay, and so you get paid in a few days, so that I'm sure that they already processed another garnishment out of that.
Yes.
So listen, if you, Mr. Rusin said the 4th of November, I mean, that's a good day, but I could give you a little bit more time, because I know you've been hit with a garnishment a few times, which would mean that we set it on the 18th of November. So you get garnished, your last garnishment would be on the 21st of October. Then you'd have to make a $300 payment, or whichever way you're gonna do it, starting on the 18th of November.
And I'll stipulate to that, Judge.
Do you understand that now?
Yes, sir.
That gives you a little bit more wind between the payments that have already been made. So those payments will be released to the plaintiff, and then the garnishment will stop after that 21st payment, and then on the 18th of November, you would make the $300 payment towards satisfying the judge. Right?
Okay.
All right, so I'm going to sign the order consistent with that. Ma'am, if you could chat your email address in the chat, I will have a copy of this document or the document sent to you, so that you could take to your payroll department, and they'll stop after this last garnishment on the 21st. They'll stop garnishments based upon the payment event.
Okay.
All right. Thank you, Judge.
Thank you.
Thank you so much.
Sorry for the wait, sir. Thank you, ma'am. Good day to you. Thank you.
But yeah,
You know what I was looking for.
yeah.
I don't know why. So, Corral T, who was that, on here? You have a case in front of you?
Yeah, Cariel Thomas.
Yeah, I think I already dealt with that case.
Thomas,
Cariel Thomas.
what's our case number?
What's your case number, ma'am?
I don't know. I just had to go to the screenshot. 1 second.
Last three digits, 882.
You already did it.
Yeah, he did it.
What happened on that case?
Oh, you granted the summary, just gave her a judgment. So.
Right.
You have it over there, or not? Yeah, I granted the motion for summary disposition in that case. You were not here at the time I called.
Yeah, I was at work and I was actually notified my employer when y'all sent out the letter weeks ago. Then I reminded her yesterday and last week, and she still managed to put me on the front gate. And she basically wasn't trying to hear it. So I had to get done doing that. And then she allowed me to join Zoom on my phone.
All right, ma'am, what you will have to do, you'll get a copy of a judgment in the mail that was entered today for the amount that was asked for in the judgment. You will have to file a motion to try and get that set aside. I regret that your employee put you in that position, but the judgment has already been granted. And so you'll need to, if you want to get it set aside, you need to file a motion to set that judgment aside and give an explanation as to why you were not here, and also provide a defense to the claim so that I can take a look at it and make a decision as to whether that should be set aside. That's what you're going to have to do.
Okay. Oh, wow. Okay. No problem. Do you know how long it would take for me to get that letter?
You'll get it in the next few days. But actually, if you have an email address, I'll have someone email it to you. Can you chat that in? You know, put it in the chat.
Yes, I do. I just sent it through.
Okay. I don't see it yet.
Yeah, it's my last name and my first name at gmail.com. I typed it.
Yeah, I'm looking at the chat right now, and it hasn't come up. That's what I'm saying. So did you chatted to the judge? But it should come up.
Oh, it went to someone named Richard Rusin.
No,
Okay.
that That was an attorney on another case. That's okay.
Oh, okay. I'm gonna send it again to where it says everyone.
I got it down. I got it down. Okay. And
Okay.
we'll that to you today. Okay.
Okay, thank you. I appreciate it.
All right. I wish you well, man.
Thank you. Bye-bye.
This is I think up top.
Mhm.
This is email.
Yeah. Kiara Thomas. I emailed, she said her first name and last name at gmail.com.
Oh, yeah, you got it. All
Yeah, I think. Yeah.
right. Do you have LaShawn Boyd?
Yes, I did hers. You gave me her. work already.
So you got her email address already?
No, not her email. You didn't give your email.
Yeah, I want you.
Okay.
Pull it off. So you have.
Oh, okay.
You know, where should we get to that
Yeah,
next
Judge,
one?
you really, I was about to say, yeah, you got a lot going on.
That's the one for LaShawn Boyd.
Okay.